You've reached FITTV. Welcome, and we'll be right back. It has been said that most of life's problems have a simple and elegant solution. It is not easy for most people to completely understand the mediation process because the education has not been available to them. It will be easy, however, for yours truly and my guest experts to do it for you. It is necessary for all of us to get on board the mediation highway. It is best to understand these new methods of resolving disputes soon, because mediation is in your future. I have with me my guests on my immediate right, Marty Goffberg, mediator, and on my left, Chuck Schalk, mediator. And we are going to, today's program will focus on why litigation is not the best choice and why our minds need a transformation toward mediation. And you have to ask yourself the question, how can you adjudicate a relationship? Amongst other endeavors in mediation, the matrimonial sector seems large that is a problem. To get the ball rolling, guys, I'm going to have you run a little adversarial court process test with the private mediation process and open your comments. In the adversarial court process, a couple abdicates decision-making to a lawyer or a judge. In the private mediation process, the couple takes responsibility for their own decisions.
Well, as a communication process, mediation allows the parties to actually talk to each other. Litigation does not allow for any real communication process because all the communication is through the lawyers and through a judge, and the parties very rarely ever get to actually come to any kind of consensus or collaboration on any kind of an issue because there's no direct communication.
As well as, their whole life up to that point, they're controlling all those decisions, okay? Raising the kids, how they're going to spend the money, how they're going to divvy up the assets, and also as well as the debt. Now it comes to divorce, now they can't make these decisions together. Why? Because in the lawyers will tell them you're not supposed to talk to the other party, we'll handle it for you. That's the worst scenario you want. You want them to work together to move forward together. And
it's the absolute worst scenario when you have children involved because you need to deal with all the child raising issues, all the issues that come along with having kids, and it's most harmful to the children not being able to have parents who actually communicate.
Let's talk about that aspect of children. On the adversarial side of the court process, you have children suffer adverse effects of the battles between parents. And on the private mediation side, children benefit as the prime focus of the mediation. That's what we focus on. We don't focus on the results of the parents.
Absolutely, yeah. Well, the thing with the children is when people get divorced, the spouses, they're not just divorcing themselves, they're divorcing the children, the grandparents. People usually take sides. And who suffers from that? The families and the children. And it's a whole social breakdown, especially in litigation, because they're taught to separate and divide and take sides. And the children suffer from that. Instead of learning to deal with the problem and work on it and move forward, they're taught to divide and take sides, and the other one must suffer.
Well, usually when I have mediations, I actually ask both parents to bring in their favorite picture of the children, so that we actually put them on the mediation table, so that the parents realize that this mediation process encompasses the children, and they are to act as if the children were in the room with them, because that makes it more real, because those are really the most interested parties in a mediation that involves any child issue of the children, and that's really the entire focus should be really on what's in the best interest of the children.
As well as that children will come out of divorce much better when the parents are working together than if they're not. If it's gonna be a love-hate thing, the children will suffer most definitely.
And also it needs to be brought out that parents are the ones that actually, in a mediation, come to the conclusions of what they need to be done, as opposed to having a judge make a court order imposing the judicial view. This way, mediation, the parents can actually make the decisions.
A particular interest in the analysis of the process is that the adversarial system, the children are often used as pawns. In the mediation process, that's not possible to use them as pawns.
Absolutely not. No ethical mediator would allow that to happen. Part of the mediation process is that as a mediator, as a facilitator, you control the communication flow, and one party becomes, has a power imbalance. One is utilizing something that the other doesn't have access to, or using just, power techniques. You want, as a mediator, to diffuse that and put both parties on the same level playing field so that they can both communicate and understand the issues going back and forth, especially when it relates to children, because the children usually have very little voice in what goes on in the mediation table, and the mediator needs to be sensitive to the fact that the children's issues constantly need to be raised, and the mediator really is the most neutral party to be able to do that.
So the voices are often called upon the children's voices are often called upon during a mediation process.
Well, a lot of the issues in the divorce,
Sure.
impact them. Their schedules, the pickup, the drop-off times relate to very directly to their activities and things that are going on in their lives. And rather than disrupting their lives for the sake of the parents need to accommodate a little bit so that the lives of the children are kept as normal as possible throughout, this process, which is extremely difficult for adults. It's even more upsetting and difficult for children who don't understand.
In looking at the framework issues of litigation versus mediation, one of the framework issues is that very often people complain about the decision that came out of court, that the court-ordered settlement was likely or potentially dangerous, and that relitigation rates could occur. Whereas in the mediation process, when you're mutually achieving that goal, right? I mean, the chance of it relitigating is minimal.
In mediation, absolutely, because the parties are the ones that create that solution.
Yeah, the mediating couple, the spouses, are making those decisions. They're owning them, and they're able to express their emotions and their feelings towards each other to allow that. It's not allowed in a litigation setting. Litigation setting, you speak to a lawyer, through an attorney, through a fax machine, through an email. There's nothing to, they can interact with each other, and that's what they need, the interaction as they had before.
And it's important to understand that when you go to litigation, you have a judge that makes decisions on your case. It's based oftentimes on maybe 5 or 10 minutes of a judge looking at a piece of paper and not really having the full input of the parties to really understand what the issues are in a very evolved and complex kind of way. It's very surface in terms of what the judge is seeing. So therefore, a lot of the decisions that he makes based on such surface, information and are very impractical for people's lives and very difficult to implement, especially long term for children who are, oftentimes a lot of what these issues come up.
Sure, it's about the children, it's about your family. I mean, when you're divorcing, you're not just divorcing your wife. There's going to be a separation issue with the children. Although you're not divorcing your children, certainly in mediation, you're keeping that kid closer by contacting the information contacts. Communication is transferring back and forth so often that the process really can't continue comfortably without the children in mind. There's also a framework issue about negotiation. No new negotiation, communication, or problem-solving skills are learned. In mediation, it's about problem-solving. It's about the dilemma that can't be brought to them by their own independent thought, and that we facilitate or we coordinate and help them come to these problem-solving issues.
The only model you have in litigation is a winner-loser, as opposed to mediation, where if you do the mediation properly, you have the parties learning how to communicate. And that's a very important process for parties to have, especially when children are involved and you have a long-term relationship going on for the rest of their lives, because they're just interconnected family-wise.
And there's many times where the couples have stopped communicating because of the emotional
Back
value.
to a point where they were actually in love with each other or saw something of value in a relationship with each other, and to try to work from there, as opposed to where they are now, in the sense of realizing that if they have children, they need to be able to work together going forward. And there's a reason they had the child, so it'd be better off to think of the positive instead of the negative.
It's tough to say that what you're saying, it's tough to expound on what you're saying without saying that's difficult in most cases to understand that a couple going through a divorce can actually redevelop or rethink or remember, right? Remember is a good word. Come back to a place where, although you may never love that person again, where you can learn how to communicate with them like you did when you first met, as you suggested.
Well, the fact of the matter is nobody gets married till they get divorced, right? And there was a love at one time, and like I said, once we get people communicating in mediation, they realize they can talk and work things out even though they want to move on with their lives. And when the mediation process works, it works terrific. It's like I said, it's not for everybody. Everyone may not make the mediation, but the mediation process itself, when it works, it's a great asset to the society and the families in the home.
The biggest problem with litigation is the concept of communication, which is non-existent in litigation, because just by its very model does not allow for communication between the parties. And that really is the essence of mediation, is being allowing the parties to freely communicate in a way that's structured, comfortable, safe, and looks out for what's in the best interest of the children.
What about the length of time? You often hear people say, you know, I've been litigating and back and forth with the lawyer. I've had 4 court appearances, and then you ask them, well, how long has that been? They said, well, it's 2.5 years now. So it's taken some people 3, 4. I've heard of cases 8, 9 years litigating, and these are matrimonial cases primarily that we do mediate. We do others, of course, but that's the bulk of where our work is, and that length of time in an adversarial process is indefinite. There's no ending point. In mediation, it's kind of like a structured plan, isn't it? Don't we develop that time to have it be, when people ask you how long will it take, because that's the question many ask.
And it depends on the parties. I mean, if the parties are willing to communicate and they're open for mediation, obviously it goes a lot faster. And even in a setting where there are no children, and I've known of mediations that have transpired with no children, with a marriage that lasted for a year or two, to actually have a divorce process last 7, 8 years, actually longer than the marriage. And when you really think about that logic, it's preposterous. I mean, how do you actually have a litigation divorce proceeding going on, 5, 6, 7 years, longer than a 2-year marriage?
Yeah.
That, there were no children, and there's, it's just the parties are so pent up.
It's hysterical.
And the court system is not, geared for any sense of the parties communicating. It just becomes war. And really, do you want to have as a society a structure that promotes really destruction of relationships and just utilizing the system just so the parties can spar with each other? And at that point, it has to be a luxury, because for most people cannot afford 7 or 8 years of protracted litigation, discovery costs. They would be completely bankrupt by the time they go through the process. So some reality check needs to be set in terms of the constraints of the litigation process.
At this point, Marty, in the time, this economy cannot support a litigation setting.
That's right.
They can't. It can't. So mediation is more attractive, not just for betterment for the family, society, but economically and time-wise. The quicker that we can get people to resolve, to move forward, they'll move forward in a positive direction. If it takes 5 years or 3 years to get going forward, it stalls the process. And by them only going, like you said before, going to the judge for 10 minutes, okay, and you get a very small piece, if anything, accomplished. Where in mediation, we can go through an hour and cover a lot of ground that it takes some years to cover in court.
Absolutely, and it's just a process that the public needs to understand, that mediation is the future. Mediation is really the only way to go in such economic times that you really don't have the funds to be able to freely litigate. And not only that, but there's not even enough court time to be able to do that. And states like Florida and California have now gotten to a point where there are even very few child custody litigations, trials going on, because the parties have mediated their solution. Even some countries have gotten to a point where they're now training judges to start, as part of the process of litigation, mediation. So it's a concept that works, and works when the parties work with that process.
Let me just add a little something to what you're saying, and hopefully that we can both expound on it too, is the cost factor built in as a difficult process, and many people are losing their entire life savings while you're in this court battle and losing your money at the same time. It also changes the amount of money you're putting into your litigation, changes the dynamic as you're in motion. The day-to-day activity of your family is never interplayed to that. So if something during a court battle should occur in a real-life sense, it gets brought up in a motion. The continuing information of motions is endlessly possible, isn't it?
I mean, you actually have, some matrimonial bar that actually base the cost of the litigation based on what the parties own and have so that they can deplete it.
Yeah.
I mean, not saying that all do that. I mean, there are a lot of excellent attorneys out there and ethical attorneys out there, but there are some that, would just absolutely load, their firms, coffers.
Yeah, that's right.
With litigants' monies only because they know that the money's there and they can just keep litigating if they just get the parties to agree to litigate. And very few attorneys offer mediation as an alternative. States like New Jersey now require that there be an affidavit that the parties are advised of their right to mediate. But it needs to be taken a step further to actually require the parties, like they do in Florida and California, to actually try mediation as a first step rather than litigating, because it's more equitable for the parties to come to a resolution.
We need to come to grips with the process of litigation and the training that lawyers and judges have in becoming a lawyer. It's kind of like the antithesis of what we train in mediation. So we know that lawyers have a purpose. I'm not trying to say that they don't have a purpose. They have a purpose in many areas. But in the matrimonial sector, it becomes very obvious that the training is opposite, isn't it? I mean, you can call it opposite to a degree. It's really reverse. It's counterintuitive.
They strictly want to be adversarial, clearly adversarial. That's what they're taught and trained, and that's what bogs down the court system. And like I said before, in some cases you need to litigate. But I would say a majority, it's not necessary, and it's destroying the social balance of this country.
Right.
And most parties think they go to court to get their day in court. That they want to be able to feel like they have the ability to talk. But the reality is when they get 5 or 10 minute increments of 15 minutes before a judge, there really is no communication, or there is no real day in court. So it's very non-productive for individuals to take that route as opposed to attempting to mediate. But the good part is there are training students in law school to mediate, and hopefully that is
that a
the
good
future.
idea? Is that because I look at that discipline as just another confounding discipline. In my mediation training, Chuck, I think we talked about this once before, the lawyers that were in the room had the most difficult time understanding the mediation process because it was counterintuitive to what they've learned.
Well, they're trained to be a rigorous advocate for their client's position. The problem I have with the concept of over-litigating is that if your case is one of first impression, meaning the courts haven't seen that kind of an issue before, or if it's such a dispute that you cannot have any way of possibly resolving it and settling it and negotiating it, then maybe litigation is right. But most cases are not cases of first impression, or ones that are so intense or new, or that require litigation. Most issues are about the family home, about a business, about children. I mean, they're very usual issues. They're not unusual or atypical kinds of cases. So therefore, people go into litigation thinking their due process rights are what's being protected. But when they actually go through the litigation process, their own individual input is very minimal. It's mostly the input of the lawyers. And
what can be determined from your input?
Right.
Perception or whatever.
So the public is what needs to be fully explained, the difference between mediation and litigation, and being given the opportunity to have a full, fair disclosure and notice of what mediation is, and their ability to be able to articulate whatever it is that they want in confidence, in a confidential setting.
We got about 6 or 7 minutes left. I want to cover a couple of basic points. First, the last basic point in comparison on the chart that we were working off of is the power is an important tool in the hands of the participants and the lawyers and the judges while you're in court in that framework, in the rigid framework. The power as a force of decision making is virtually eliminated in mediation. When you take away that power.
Well, absolutely. The power is brought from the courtroom to the spouses. They're going to make the decisions themselves on how they want to handle what they have to handle in a divorce case, as opposed to a judge. And you don't even know what you're going to get with a judge. Each judge, each district can give a different version of what they feel the law is. And people don't understand, the public doesn't understand, that they think that they go into court with an assumption of how it's going to go because they talked to a friend or a lawyer who thought that was going to go, and it doesn't work out that way, and then they're disappointed, when in actuality, I was walking through Nassau County Matrimonial Court, and I saw many lawyers in a conference room, actually in a form mediating, okay, but in a law setting, but they were mediating, and they came out with settlements before going to the judge. So in actuality, I think they kind of mediate anyway, in a way, but they're not admitting to it.
Mm-hmm.
But there's a lot of negotiation, but without the actual parties' ability to actually, offer what it is they want. Oftentimes, it's the attorneys negotiating, thinking what is in the best interest of their client, when really the actual best result would be between the clients. So again, the rules of court are very different. People don't realize that because of the rules of evidence, the rules of civil procedure, they have very little input directly as to what goes on and transpires in a court litigation. They think they're going to get their day in court, but they really don't have any opportunity to really put forth their voices in their own unique way, which they can only do in a mediation, and which is being taken away in not allowing them, or advising them that they have that right. And most attorneys, most cases are settled. Most 85% of most cases are settled, but usually between the lawyers with, occasionally speaking to their clients. If you take it more into a setting of a mediation room, I guarantee you that the resolution that you get in mediation would far outlast those that are done by a third party, because it's direct party, results that matter most.
Let's talk about what a mediator needs to know based on law. What do they need to know about law, and do we need to know much about law as we mediate?
Well, it helps to understand the process. But I believe that if you have the appropriate training and qualifications as a mediator in understanding fully what the court system is about, what the various issues are, you need to obviously know the mechanics of matrimonial issues in terms of
child support percentages, or whatever,
proceedings.
Well, custody is a major difference, because in New York we don't have a custody state law that says this joint custody. But I noticed that in all my mediations, almost everybody is getting joint custody. And by the way, when I say is getting, they're primarily asking for it.
Well, and training in terms of setting up a parenting plan, setting up, settlement as to who gets the house in terms of equitable distribution kinds of issues, in terms of homes and pensions and quadros and all kinds of other things that are important. But it's also, I think, important for mediators training to be able to understand the issues of communication and being able to facilitate a dialogue freely, between the parties, and making both parties feel that they're comfortable and that they have their opportunity to put forth whatever it is they want on the table.
And one important element of mediation is that we have the review attorney. At the end of the process, we encourage the spouse to take it to independent review attorneys so they can go over with an attorney to make sure that they understand what the legal ramifications are.
And it's important for the public to understand the mediators don't make any decisions. The parties do, and the parties are always encouraged to get independent legal advice so that all of their rights are protected. But the process is one that goes a lot more expeditiously. It's more cost efficient, and it's one in which the parties actually have some satisfaction of being the solution and coming up with whatever works for them.
Are you familiar with the use of language as being different? Like there's several different forms of mediation. There's transformative and facilitative. We know what those things are as basis. Is it? Do you know it quick enough to tell the difference? Like transformative has changed the picture of how they've understood things and make them go back to another life. Transformatives tend to have reconciliations appear because they're working more with personalities. Facilitative, you're drawing, right? You want to explain?
Right. I happen to be more comfortable in the facilitative mode, right, because I think all the different kinds of variations on facilitation sometimes work, sometimes don't work. The basic concept is that of getting communication between the parties. The transformative tries to go a little bit further and try to actually transform the parties on various different positions. It works for some, it works sometimes, for example, the postal redress system, where they're trying to transform behavior from aggressive to less aggressive, or those kinds of issues where you have substantial issues that you need to work with.
What do you do, sir?
Actually, I think it's a blend. I do a blend, believe it or not, because depending on the couple, To me, I
That's right, yeah.
evaluate the couple, and some couples need facilitative. Some couple works better to be transformative. They need to speak. They need to get things off their chest and allow them to work it out a little bit themselves, and then you jump into facilitative mode when the time is right.
I find most mediators would agree with that. They kind of float along to see
Yeah,
how
I
the
mean,
couple's
I use a
responding.
blend.
Yeah.
I use a blend of it, but it's true. I mean, you need to have that facilitative ability at, before you get to the other levels of.
Absolutely, no.
of
Facilitative
mediation.
is a main requirement, because if they could do it on their own, they would have done it already.
Yeah. What I find most interesting about mediation is the differences in language. There isn't any demands, any motions, any things like that. There's possibilities. There's problem solving. There's things that that you don't use in the court.
But when you're using evaluative, you need to have a little more, than surface, but more subject expertise in terms of being able to evaluate a particular situation in order to put forth different options that people have. I mean, most mediators get their power from asking questions of the parties, because the parties are the ones that have the answers. And the trick is in framing the questions that are in a way that are neutral, and that try to get some commonality of interest between the parties. You want to try to get and work on everything that is working cooperatively, collaboratively, and building on that. So you don't want to try in a mediation to use other blends, and all of a sudden you have the parties splitting apart.
What occurs to you in terms of how you would describe, because we only got 1 minute left, what occurs to you that how would you describe to the audience one drastic or clear-cut measure that says this is the reason why you need to pay attention to mediation? What is it that the audience wants to hear?
Well, I
what
think
can we tell them?
John Q. Public needs to know that mediation works. That when you have two willing parties going into a room and have a qualified mediator, you have more of a chance of success in terms of a long-lasting, durable success.
When parties are involved in decision making, when you decide to buy a house or anything else, you're involved. And when you're involved in mediation, in your problems and going forward, it will work together and it will be resolved, and it will stick. You will both agree to it, and it will much less chance of them being adversaries to it.
Right, I'm going to agree with this quickly, that when you're making your own decisions, you're more likely to stick to them. There's no question about it. And then I have to ask the blanket question is, how do you adjudicate a relationship? Okay, where do you start? Because that's what it's about in the matrimonial sector. Thanks very much, Marty Goffberg and Chuck Schalk. Societal and political trends are rapidly breaking down the family that once was the cornerstone of our great American culture. At FIT, we know you cannot get this information on your own, so we'll bring it to your TV every week. And of course, we always invite all opposing views. My name is Chris DiMaggio, and I thank you very much for watching FIT TV, and we'll see you again next week.